strike or lockout shall be illegal. Under what circumstances a strike or lockout shall not be deemed to be illegal? So tell me the circumstances under which strike or lockout shall be illegal and under which circumstances it shall not be deemed to be illegal. A strike or lockout is illegal if number 1 it is commenced or declared in contravention of the provision of the act regarding prohibition of strike and lockout as contained in section 22 or and 23, or number 2, it is continued in contravention of an order made by the appropriate government for prohibition of its continuance under section 10 subsection 3 or section 10a 4a 10a clause 4a of the Industrial Dispute Act. So there are two conditions under which a strike or lockout shall be illegal. So what are those conditions? Number 1, it is commenced if it is started or it is declared in violation of the provision of the act regarding prohibition of strike, lockout as contained in section 22 and 23, or number 2, it is continued in violation of an order made by the appropriate government for prohibition of its continuance. Prohibition of its continuance under section 10 subsection 3 or section 10a clause 4a of the Industrial Dispute Act. The following are the circumstances in which a strike or lockout shall not be deemed as to be illegal. The strike and lockout shall not be deemed to be illegal if number 1, at the commencement they are not in contravention of the provision of this act. Number 2, their continuance has not been prohibited by appropriate government unless under section 10 subsection 3 or subsection 4a of the section 10a. Number 3, a lockout is declared in consequence of an illegal strike, or a strike declared in consequence of an illegal lockout shall not be declared to be illegal. That means if a strike is declared in consequence of an illegal lockout, then that strike shall be treated as illegal. We cannot say it is illegal. Vice versa, if a lockout is declared in consequence of an illegal strike, then that lockout shall be declared as legal. So when a strike or lockout shall not be deemed to be illegal, or in or other words shall be termed as or treated as legal, when at the beginning there are no violation of provision of the act. Number 2, their continuance has not been prohibited by appropriate government under section 10 subsection 3 or subsection 4a of this section 10a. Number 3, a lockout is declared in result of an illegal strike, or a strike is declared in result of an illegal lockout, shall not be deemed to be illegal. That must be treated as legal. So this is the video in which on what grounds or on what situation lockout or strike shall be termed as legal, and on what conditions it shall be treated as illegal. So there are 2 points. One, illegal points when it is at the beginning or on declaration there is a violation of provision of the act regarding the prohibition of strike and lockouts is contained in section 22-23, or it is continued in result or in violation of the order made by the appropriate government for its continuance under section 10 subsection 3 or section 10a clause 4a of the Industrial Dispute Act. So next topic, what is the offense of to give financial aid? Is it an offense to give a financial aid to a illegal strike or lockout? Discuss. Section 25 of the Industrial Dispute Act provides that no person shall knowingly spend or apply money in direct furtherance or support of any illegal strike or lockout. If you are spending money or applying money to direct to fund or support any illegal strike or lockout, that is not permissible. That is not permissible under Section 25 of the Industrial Dispute Act. The Act provides that any person who knowingly spends or applies any money to direct furtherance of any illegal strike or lockout shall be punishable with imprisonment for a term which may extend to 6 months. If you are applying money or spending money to the illegal strike or lockout knowingly, then you shall be punished for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. This is the punishment prescribed under Section 25 of the Industrial Dispute Act. Thus, for prosecuting a person for contravention of Section 25, the prosecution must prove: number A, that a strike or lockout was illegal. Number B, that the accused has the knowing knowledge that the strike or lockout was illegal and the money spent by him was in direct furtherance or support of the same. Number C, that the money was spent by the accused. The three conditions, the prosecution has to prove the three conditions. Number one, the strike or lockout was illegal. Number B, the accused must have the knowledge that the strike or lockout was illegal and the money spent by him is direct furtherance or in support of the same. Thus, there must be the direct support or furtherance of the illegal lockout or strike. Number C, the money was spent by the accused. There must be some spending by the accused. So these are the three conditions which the prosecution must prove in order to punish the accused under Section 25 of the Industrial Dispute Act, that is the punishment of 6 months imprisonment, of 1000 fine, or both. Section 27 of the Act provides that any person who instigates or incites others to take part in or otherwise acts in furtherance of a strike or lockout, which is illegal under this Act, shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. That means if you are instigating or inciting others, you are motivating others, you are exciting others, you are inciting others, you are instigating others, please take part in the furtherance of this strike or lockout, that is illegal under the Act, then you shall be punished with imprisonment for a term of 6 months, or with fine which extends to 1000, or with both. It may be noted that the word used here is instigating and not participating. Hence, for persecution of a person for the purpose of the fact must be analyzed and circumstances to be looked into. According to Section 28, any person who knowingly spends or applies any money in direct furtherance or support of any illegal strike or lockout shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. However, the person spending or applying money must know that the strike or lockout is illegal. This is already stated in the Section 25. The person must have the knowledge that the illegal strike is illegal or lockout is illegal. So according to the same thing is mentioned under Section 21, any person knowingly spends or applies any money in direct furtherance or support of any illegal strike or lockout shall be punishable with imprisonment extend to 6 months, or with fine 1000, or with both. However, the person applying spending or applying money must know that the strike or lockout is illegal. Accordingly, mens rea is a necessary element of an offence under this section. Must have the knowledge. If you are unknowingly spending money, then that shall not form the offence mentioned under Section 25 or 28 of the Industrial Dispute Act, because mens rea, knowledge of the offence, is the main element. Criminal intent must be the main essential ingredient in order to form the offence under this section. State of Bombay versus Canfield, Holland, 1953, 1 LLJ 458 bomb. Section 26, Clause 1 contains the following punishment of a workman who continues, or otherwise act in furtherance of an illegal strike. Number 1, imprisonment for a term which may extend to 30 days, that is 1 month, or number 2, fine to the tune of 50 rupees, or both. Section 26, Clause 2 contains the following punishment for an employer who commences, continues, or otherwise act in furtherance of an illegal lockout. Number one, imprisonment for a term which may extend to 1 month, that is 30 days. Or number two, fine to the tune of 1000 rupees or both. 26. Clause 1 contains the following punishment for a workman who commences, continues, or otherwise act in furtherance of an illegal strike: imprisonment 30 days or 50 rupees fine or both. And 26. Clause 2 contains the following punishment for an employer who commences, continues, or otherwise in furtherance of an illegal lockout: imprisonment for a term which may extend to 1 month, 30 days, or fine to the tune of 1000 rupees or both. 26. Clause 1 contains punishment of illegal strike of a workman who continues, commences, or act to support an illegal strike. He is not funding the strike. He is not funding the strike. He is supporting it. He is beginning it or continuing it. Then he will be imprisoned behind the bar for 30 days or 50 rupees fine or both. 26. Clause 2 states, if there is the illegal strike by the employer, it provides the provisions for punishment of the employer: the imprisonment behind the bar 30 days, 1000 rupees, or both. This is the punishment mentioned under section 26 clause 2 of the Industrial Dispute Act to the employer. What is the penalty for an illegal strike or lockout? Section 26 clause 1 of the Industrial Dispute Act provides that any workman who commences, continues, or otherwise act for furtherance of a strike that is illegal in this act shall be punished with imprisonment for a month, for a term which may extend to 1 month, or with fine which may extend to 50 rupees, or with both. Again, according to subsection 2, an employer who commences, continues, or otherwise act in furtherance of a lockout which is illegal under this act shall be punished with imprisonment for a term which may extend to 1 month, or with fine which may extend to 1000 rupees, or with both. Since the Industrial Dispute Act, which creates rights and remedies, has to be considered as an homogeneous whole, it has to be regarded uno facto, in one breach as it were. On this doctrinal basis, the remedy for the illegal strike has to be sought exclusively in section 26 of the Act. The claim for compensation and the award thereof in arbitral proceeding invalid as it fact. Such a compensation for loss of business is not a dispute or difference between the employer and a workman which is connected with the employment or non-employment or the terms of employment or with condition of labor of any person. Rohtas Industries Limited versus Rohtas Industrial Staff Union, EI 1976, Supreme Court 425. Prohibition of unfair labor practice. By the 1982 amendment in the Industrial Dispute Act, a new chapter 5C has been added dealing with the prohibition of unfair labor practice. It commit any unfair labor practice. If any person commits unfair labor practice, he shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. Layoff and retrenchment. What is meant by 1 year of continuous service? A workman who, during a period of 12 calendar months, has actually worked in an industry for not less than 240 days, that is minimum 240 days, shall be deemed to have completed 1 year of continuous service in the industry. In computing the number of days on which a workman has actually worked in an industry, the following days shall be included. Number one, the days on which the workman has been laid off under an agreement or as permitted by standing order under the Industrial Employment Standing Order Act 1946, 20 of 1946, under Industrial Dispute Act or any other law applicable to the industrial establishment, the last number of days during which he has been so laid off being taken into account. That means these days, these days of laid off shall be included. The days on which he has on leave with full wages earned in the previous year. These days shall be included. Number 3, the days on which he has been absent due to temporary disablement caused by accident arising out of or in course of his employment. These days has been included. Sundays and other paid holidays during which a workman was in employment of an employer and for which he has been paid wages. Workmen of American Express International Corporation versus Management 1985. Uh, these days would be included. The days on which in the case of female he has been on maternity leave, which in the aggregate shall not exceed 12 weeks. 12 weeks shall not be exceeded. These days would be included. What is Badali workman? What are the rights of compensation of workman who has been laid off? Badali workman means a workman who is employed in an industrial establishment in place of another workman whose name is borne on the muster roll of the establishment but shall cease to be regarded as such if he has completed 1 year of continuous service in the establishment. Workman means a workman who is employed in an industrial establishment in place of another workman whose name is borne on the muster roll of the establishment but ceases to be regarded as such as the Badli workman if he has completed 1 year of continuous service in the establishment. Badli means the temporary workman. It means to say. But if he completed 1 year of service, then he would not be considered as Badli workman. He would be considered as the regular workman. Whenever a workman other than a Badli workman or a casual workman whose name is borne on the muster roll of the industrial establishment who has completed not less than 1 year of continuous service under the employer is laid off, he shall be paid by employer for all days during which he is so laid off, except for such weekly holidays as may intervene. That means if he has completed 1 year of service, then he would be entitled to get the benefit of what? Entitled to get the benefit of laid off. Under an laid off, if he is laid off, then he shall be paid by the employer for all the days which he is so laid off. Then he shall be paid by the laid off days. Other than the weekly holidays, as may intervene, weekly holidays shall be excluded, but apart from that, he shall be paid for the laid off. Compensation which shall be equal to 50% of the total of the basic wages, dearness allowances which would have been payable to him, and had he not been so laid off. If he, that means what would be the basic salary dearness allowances? The total amount 50% of the total amount would be paid as the compensation for the laid off. Yeah. But the compensation payable to any workman during the any period of 12 months shall not be more than the 45 days. That means whatever would the compensation that shall not exceed 45 days. If during any period of 12 months a workman is laid off for more than 45 days after the expiry of the first 45 days, comprises continuous period of 1 week or more, the workman shall, unless there is an agreement to the contrary between him and the employer, be paid for all days comprised in every such subsequent period of laid off at the rate of 50% of the basic wages and allowances. But in, su- in such cases, it shall be lawful for the employer to retrench the worker and in accordance with the provision of law at any time after the expiry of the first 45 days of layoff, and where he does so, any compensation paid to the workman for having been laid off during the preceding 12 months may be set off against the compensation payable for retrenchment. Exception, however, the above provision regarding compensation shall not be applicable. Number 8, to industrial establishment in which less than 50 workmen on an average per working day has been employed in the preceding calendar months. Or number B, to industrial establishment which are of a seasonal character. or in which work is performed only intermittently. Thus, Section 25C confers on the workmen who are laid off the right to compensation and prescribes the methods on which the same has to be calculated. Only those workmen can claim the benefit of this section who are workmen laid off for reason contemplated by Section 2 Triple K 1964 1 LLJ 358 S Supreme Court. In case of any dispute, an industrial tribunal can determine the question whether an employer was responsible for deliberate bringing about the situation leading to layoff, or whether the workmen were laid off in order to victimize them for some ulterior motive. Such finding of fact arrived at by the tribunal are not to be interfered by the High Court in its writ jurisdiction under Article 226 of the Constitution, 1962, ILLJ 382 Supreme Court. So that's all about this video. If you find any value to the video from the video, please like or subscribe my YouTube channel.